Hey everybody, thank you guys so much for coming out. My name is Rob Esrock. I'm the Chief Justice of this 2019-2020 Sherman Minton Advocacy Board. It's been my great honor to serve in this role. I just want to take a minute and talk a little bit about the competition, about the competitors, and some of the people that made this possible. As some of you guys may know, our competition is named after Justice Sherman Minton, who was an Associate Justice of the United States Supreme Court. His picture hangs back there in the back of the courtroom, and he is watching the arguments tonight, I'm sure. I also just want to thank all the friends and family of all the competitors who came down tonight. It makes a huge difference to have your support, so thank you all for coming. For the last 8 months, our board has been designing, organizing, and running this competition, the largest student event in the law school. The competition itself took place over the course of 3 months. It involved 130 students, 132 judges from around the country, and countless other people. Needless to say, an event of this magnitude would not be possible without the support of many people, and I'd like to recognize some of those people now. First of all, I would like to thank our competition board. The competition board consists of 3L students who have a passion for advocacy. These individuals have done a tremendous amount of work over the course of the semester, from judging arguments to grading briefs to serving as liaisons between competitors and judges, among many other things. They made this competition truly seamless. So if you were on the competition board, can you please stand and be recognized? Next, there are several people whom I'd like to acknowledge individually. If you're in the room when I call your name, can you please stand? And the audience, can you please hold your applause until the very end? First, Chelsea Browning, who's the reason why today's event is even possible. Second, Professor Inga Vandercruz, who's the reason why we have such an amazing panel of judges before us tonight. Dean Turchi, who helped us promote the competition and prepare for today's event. Marion Conity, Paul Stiles, and Brian Seymour, who helped us with everything AV related. Libby Steinbach, who helped us with logistics. Professor Natalie Ram of the University of Maryland Carey School of Law, who offered her expert opinion and advice on drafting our problem. Dean Scott, Professor Tomaine, and Dean Parrish, who also offered advice about the problem and who graciously appeared in our podcast. Director Beck and Dean Ornstein, who offered their perspective and unwavering support. Adam Priest for writing a hilarious skit, which we will play for you later. And anybody else in the audience who may have judged the competition or served as a bailiff. Thank you all very much. Last, but certainly not least, I would like to introduce 11 of the smartest, hardest working people I've had the honor to work with, the executive board. These individuals care so much about this competition. Their passion, creativity, and amazing work ethic is unparalleled. It's my absolute pleasure to work with these people. Now, some of them are still doing their job outside and they're not in the room right now, but if you are in the room, if you could please stand and be recognized. Audience, again, I would ask you if you please hold your applause until the end. First, our Executive Advocacy Coordinator, Allison Hilmer, who manages the external competitions and runs our Mauer's annual mock trial and alternative dispute resolution competition. Next, our Executive Competition Board Coordinator, Seamus Appel, who manages the 28-member competition board, a tremendous responsibility. Next, we have our Executive Judge Coordinators, Betsy Astrup and Sam Carson, who somehow persuade lawyers and judges to take time out of their busy schedules to come down and judge moot court, and who make sure that these judges are well informed about the problem. Our executive problem coordinators, Emily Gilliam, Daniel Thompson, and Evan Anderson, 3 of the most creative people I know who have spent innumerable hours researching legal issues and current events, coming up with creative ideas, and tweaking and perfecting the problem that the competitors are arguing today. Our executive competition coordinators, Amanda Vaughn, Mary Rachel Durso, and Ben Wade, the organizational masterminds behind this competition, whose work I never had to second guess, and who went above and beyond every single chance they got. And lastly, Professor Seth Lawn, our faculty advisor. I've learned so much from working for you, Professor Lawn. Your passion for this competition is unmatched. Your great intelligence and wisdom are the reason why this competition has such a great reputation and why it's lasted for 54 years. A big round of applause for our phenomenal board, please. This competition began in September when we released a case problem to the competitors. In teams of 2, they wrote appellate briefs, which were later scored. They then participated in 2 rounds of oral argument. Their brief scores were combined with their oral argument scores, and the top 64 competitors advanced to a head-to-head single elimination bracket. The top 4 finalists are now arguing before you today. At the end of the day, 2 of them will be declared champions. However, there were several very worthy competitors who could have very easily been standing here today. I'm now going to turn it over to Amanda and Mary Rachel to introduce some of these competitors, the top 32.
Hello, everyone, and thank you again for coming tonight. This competition would not have been possible without the 130 competitors who decided to participate in the 2019 Sherman Minton Moot Court competition. We saw some fantastic arguments throughout the course of this semester, and we would like to take a few minutes to honor today's top 32 competitors. As we call each person's name, please stand up and remain standing until the last person in your group has been called. We ask that the audience please hold their applause until the last name. First, the octo finalists, which are the top 32. Josh Felty, Melanie Grossman, Clara Gutwein, Drew Halter, Andrew Ireland, Shane Kelly, Callie Kidwell, Kevin Crotchide, Ziyu Ma, Zach Pfeiffer, Jordan Sainer, Mary Strong, Tanner Watson, Joseph Wiegand, Trevor Warby, and Rita Zia.
We'd now like to recognize our quarterfinalists, Shayna Galloway, Ben Burdick, Mary Kate Hetzel, Alex Pantos, Garrett Moores, Reese Sobel, Willow Thomas, and Alexa Wilson.
And now for the semifinalists. Audrey Brittingham, Estefano Martinez, Janelle Shankin, and Liam Williams. Again, congratulations to all of you on an amazing accomplishment. Additionally, we would like to refer everyone here to the program to recognize the names of the students who received both brief writing and oral advocacy honors, as these are also great accomplishments in this competition. And now we're going to pass it off to Emily and Dan from the problem team to explain what everyone's going to be arguing about tonight.
Thank you again to everyone for being here tonight. I'm Emily Gilliam, and I, along with Evan Anderson and Daniel Thompson, are the masterminds behind this year's case problem. This year's problem integrates 2 burgeoning areas of privacy law, DNA and big data. Specifically, whether you have a privacy right in your DNA and whether that right can be overcome under exigent circumstances. And also whether you have a constitutional right to sue or standing to sue if your personally identifiable information is leaked but not actually misused as a result of a data breach. Our story begins back in March, when a newly discovered noxious disease was found in an ancient reindeer carcass off the coast of Greenland. This disease, named green isle after its origin, is unknown to modern human immune systems. It is deadly and spreads with unprecedented ease. Green isle quickly made its way south and penetrated the fictional state of Arcadia and the city of Lockton. The Lockton Health Department immediately initiated its protocol for mitigating disease outbreaks, which included tracking down individuals thought to be infected with the virus and testing them. One such individual was Rosemary Deacon, our plaintiff in this case, who was an unsuspecting graduate student and part-time waitress in Lockton. After visiting a contaminated convenience store, Deacon was flagged as possibly infected, so a health department official came to her home to test her for the virus, which consists of a buccal swab to the inside of the cheek. Deacon protested, but ultimately the swab was taken anyway and tested at the health department. Deacon indeed was found to have tested positive, but didn't appear to have any symptoms of the disease. Suspecting she might have some sort of genetic immunity, the health department officials retained her sample, which contained her DNA, and sequenced a portion of it to use for research. This taking, retention, and sequencing of her DNA gives rise to Deacon's first claim, which is a constitutional due process claim. She says that under the 14th Amendment, she has a privacy right in her genetic information and that the city's actions violated that right. The city argues that there is no such privacy right in one's DNA, but even if there was, its actions were justified because of the pressing public health crisis. But Deacon's problems didn't end there. I'm going to now turn it over to my colleague Dan to discuss what happened next.
Thanks, Emily. So in the middle of this public health crisis, the city of Lockton is also facing another crisis, a data breach crisis. So Emily had previously mentioned that Officer Love had came to collect the information and then stored it in the city of Lockton's database. Well, before that, we have a character, the Grim Breacher, who had previously stolen two separate instances of another data breach. One at a hospital, and at the other at the city councilman's office. So he eventually gets to the city health department and has a third instance of hacking and steals the PII, the personal information of both Rosemary Deacon and her genetic information. Thank you. I think this is going to be a little bit better. Can you guys hear me? Thanks. And so now that Grim Breacher has this information, Rosemary Deacon finds out about it. And so she decides to amend her complaint to add a negligence claim against the city of Lockton for negligently handling their security protocol. But in order for her to do this, she has an issue. She has a constitutional standing problem. In order to bring a suit, you have to meet the requirements of Article 3 of the Constitution, and one of those requirements is that you have to suffer an injury. Now, the Supreme Court, in limited circumstances, has identified future harms as being one of these types of injuries, and this is one of those instances where Rosemary Deacon may or may not, we're about to find out, have suffered a future harm. In order for that future harm to satisfy the Article 3 requirement, that harm has to be certainly impending. So Rosemary Deacon is going to argue that her harm, that being that the Grim Breacher has stolen her information, but hasn't yet stolen her identity, which would be the actual harm, whether or not that is certainly impending. So of course Rosemary Deacon will argue that that injury is certainly impending, and then the city of Lockton will argue the opposite, that it's not certainly impending. So in a moment you guys will hear those arguments. Also after those arguments, you're more than welcome to go outside. There'll be some hors d'oeuvres, but we'll also have a fun video to play for you guys that'll kind of encapsulate a lot of the themes from this year's problem. We put a lot of hard work in that video, so I hope you enjoy it. So Rob, I think it's up to you now.
Thank you, Dan and Emily. All right, everybody, so we're going to convene court now, so please turn your cell phones off if they aren't already. Also, please refrain from leaving during the arguments. If you must leave, please do so as quietly as possible in between the arguments. Thank you very much, and we hope you enjoy the competition. Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. We are here today to hear the case, the City of Lockton, Department of Public Health versus Rosemary Deacon. Would the petitioner begin, please?
Good evening, Madam Chief Justice, and may it please the Court. My name is Dakota Coates, and I represent the petitioner of the City of Lockton's Department of Public Health. We are here today to respectfully request that this Court reverse the Circuit Court's decision and grant the petitioner's motion for summary judgment. Tonight, we will assert that the Circuit Court erred in finding that the respondent had a privacy right in her DNA, and that the Lockton Code 105A is rationally related to the prevention to the spread of disease. Alternatively, we will assert that the Circuit Court incorrectly applied strict scrutiny analysis, as the statute in question is narrowly tailored to address the state's interest at hand. Now, this Court, in analyzing fundamental rights and liberties, has often searched through our history, our tradition, and our legal practices to discern whether or not a right is implicit in our ordered liberty. With regards to privacy, this Court has generally recognized two particular areas: decisional privacy, the right to make particular decisions, and informational privacy, the right to confidentiality with regards to certain information. However, this Court has also recognized that neither of these are absolute, nor are they all-encompassing. With regards to the issue before us today, Rosemary Deacon has asserted that when it comes to taking one's DNA for the purpose of preventing the spread of disease and ensuring that the city can protect its citizens, that it violates both of those rights. However, Your Honors, that is simply not true. When we look to this Court's own precedent in Maryland v. King, they found that a buccal swab does not violate the right to privacy.
But wasn't that a very different kind of situation involving the Fourth Amendment and someone who had been arrested?
It was dealing with an arrestee, yes, Your Honor. However, this Court highlighted more accurately with regards to the buccal swab itself and analyzing that the reason that it didn't violate a privacy concern was that the buccal swab was a quick and painless procedure, that it required no surgical intrusions, it offered no threats to one's health or safety, it offered no trauma, and in terms of a general medical procedure, it was a minimally intrusive act.
Do any of those factors have to do with privacy?
It goes to the concept of whether or not the individual had their internal self violated. So with regards to whether it was an arrestee or a regular individual, since it was such a minimally intrusive medical procedure, the Court in that instance found that yes, in the context of the Fourth Amendment, it did not violate privacy. Those same principles would apply in general with medical procedures, Your Honor.
Don't we have to look beyond here, though, since the DNA was taken from the swab and then sequenced? Doesn't that make a difference?
So that would go to in part to the informational concept of privacy. With regards to the sequencing of DNA, this Court has often found that when it comes to the collection of information with regards to medical records, in particular when they are targeted at preventing the spread of contagious diseases, that it rises to a separate level. That just because it is a general medical information does not mean that you are guaranteed to a particular set of protections. In fact, I would point to the fact that the respondent has highlighted various state and federal legislative actions to kind of highlight that we have this sense of genetic privacy in our country. However, that's not the full story. When we look to HIPAA and when we look to the 10 state statutes that the respondent highlighted in their brief, in every single one of those statutes, there is an exemption for non-consent with regards to the release of information for medical purposes, and a majority of those statutes provides a release for the ability to address the spread of contagious disease, in particular when it's deadly or lethal diseases in question.
Well, one thing that's bothered me about this is it's one thing to take a swab to see if Ms. Deacon had a disease, the disease of this green Nile virus, whatever.
Yes, sure.
But it's another thing to sequence her DNA for other purposes, because you decided that she was testing positive, but my understanding of the disease is you come down with the disease within 7 days of being exposed. So you decided that she was tested positive, but did not have the disease. So why doesn't that stop any interest that the city would have?
With regard to the test, she was positive for the disease, but was not showing symptoms of the disease. And so on that basis, the city continued to enact in its duties under Lockton Code 105A towards the efforts of preventing the spread of diseases. So it was that once we found an individual who is showing that they are able to be positive and yet not succumb to this lethal disease, it allowed for the opportunity to, again, fight the spread of this disease by trying to attempt for a cure. So the sequencing of the DNA was not for any other purpose than the continued effort to prevent the spread of the disease. It wasn't
Counsel, it seems to me like you're really mixing apples and oranges. But what I'm particularly interested in this case is, doesn't this really boil down to Ms. Deacon's fundamental rights as guaranteed to her by Roe versus Wade and Griswold versus Connecticut?
Are you in reference to the general right to privacy, Your Honor?
Yeah.
Well, the right to privacy, as this court has often said, is not absolute nor all-encompassing. That there are certain exceptions to the right to privacy, and it doesn't expand to all categories just because an individual would like to assert that there is a right there. It has to be rooted in our traditions and our legal practices, or implicit in the Society of Order and Liberty.
Well, no, perhaps maybe I wasn't articulate enough. Doesn't it come down to what, in fact, Roe versus Wade and Griswold provide and instruct? Doesn't Ms. Deacon have a fundamental right to make decisions about her body, which your client is infringing on?
With regards to the fundamental right decision of bodily autonomy, that would be making the assumption that DNA and the body are completely the same. With regards to DNA, we shed our DNA constantly throughout every day, through the hair that we drop, through saliva that we release.
No, we're talking about decisions. The decision of what can be done with her body and the products of her body.
Again, with regards to the chance of medical decisions, this court has also been of the opinion, though, that with not all decisions are protected under this right to privacy. Again, with regards to certain medical procedures and certain medical decisions, if they are for the purpose of preventing the spread of diseases, and if they are minimally intrusive actions in those decisions, the courts, both in this court and in the lower courts, have often held that those are permissible under the Constitution.
Other than Maryland versus King, what case have we decided that supports that proposition that you just stated?
With regards to the option of medical procedures, Your Honor?
That would support your idea that they can require Ms. Deacon to give up her DNA. It's not that she has voluntarily shed it somewhere, but that you can force her to so-called voluntarily give up her DNA and have it be sequenced.
Well, there is not a case on point for DNA. The case that I would point to would be Jacobson v. Commonwealth of Massachusetts. In that particular case, the Supreme Court was analyzing the use of health laws with regards to mandatory vaccination. So whether or not they could make the decision to vaccinate an individual. In that case, the Supreme Court held that it was permissible under the Constitution. In particular, they looked to the fact, again, that it was heavily rooted in the basis to prevent the spread of disease, and also that it was enacting a higher level of deference to the legislature, as this court has held multiple times when it comes to these prevention and spread of diseases.
And in that case, was it that there was no privacy interest, or that ultimately they were able to show that this was a narrowly tailored way of achieving a different compelling interest? Because it seems to me that the extent to which it prevents disease or not goes to whether or not this could pass strict scrutiny, not to whether or not there's been an invasion of her privacy.
In that particular case, it was that they did not find a right to privacy at all. But moving on to your...
Well, which circuit would you recommend us to look to with regard to the appropriate medical privacy holding that would apply to your client's case?
We would ask you to look to the 10th Circuit with regards of the decisional privacy, or the informational privacy, and then the 9th and 6th Circuit with regards to the decisional privacy.
If we applied the 10th Circuit case, how do you win?
So the 10th Circuit case limits the release of medical information to only that information which would be would open up an individual to public discrimination. In that case, it rose to the level of fibromyalgia. The 10th Circuit has similarly looked at other particular statuses. The most prevalent would be one's HIV status, in which they found that that did not open up an individual to the level of discrimination necessary to violate that. And
Why wouldn't her potential immunity based on her DNA open her up to more public scrutiny here, and therefore you would not prevail?
Your Honor, that would be operating under the assumption that an individual would be able to look at a broad sequencing of genetic information and be able to discern what those indicators mean. The city's experts themselves, on page 44 of the record, have highlighted that that their experts themselves struggled to go through decoding the DNA and going through that analysis.
Is there anything in the record that decoding was listed in the files that were actually stolen?
The
Results of it. So you said somebody wouldn't be able to go through and figure this out, but was that already in the files that were stolen?
There was an abbreviated note of a possible immunity, yes, Your Honor.
So wouldn't that work against you?
They would, again, on that as a basis of discrimination, I think that immunity would not rise to the level that the 10th Circuit has often required for that discriminatory purpose. To move on back to your question with regard to strict scrutiny analysis, we would argue that this law would also be able to sustain the strict scrutiny.
Counsel?
Yep.
In that vein, how can you suggest or establish that Section 105A is in fact narrowly tailored when it actually authorizes DNA collection sequencing, which has no relationship to disease prevention?
Respectfully, Your Honor, I would disagree. It has been common practice with the revolutionary technology of DNA to utilize DNA markers in terms of genetic predispositions and genetic information that would point to an immunity to be able to synthesize a cure. We're not talking about
general research here. We're talking about the interest in preventing, what is it, green owl disease?
Yes, Your Honor.
Green
That has to be the narrowly tailored purpose here, right?
Yes, it goes towards
doesn't, to the extent that 105A actually allows the city to collect and sequence DNA, which actually has no relationship to stopping the immediate spread of the disease, isn't that broader than what the city is entitled to do?
Well, there are two parts to that question. With regards to synthesizing the DNA to establish a cure would be the pinnacle of preventing the spread of disease. If we were able...
No, you're forgetting one piece, immediate. It might be the pinnacle sometime down the road, but I believe it needs to be to prevent the immediate spread of the disease.
Yes, Your Honor. With regards to the general collection overall, the statute does permit the germane... And I'm out of time.
You may answer the question.
It does permit the collection of information germane to the spread of disease. And so if we were able to have this information from Rosemary Deacon for indicators of immunity and be able to compare that to other immune individuals, it would be beneficial to an overall analysis.
Thank you.
Yes, Your Honor.
Madam Chief Justice, and may it please the court. My name is Noah Vancina, counsel for the respondent, Rosemary Deacon. In this case, the 14th Circuit has held that the collection, retention, and use of Rosemary Deacon's DNA violated her fundamental right to privacy. The judgment of the 14th Circuit should be affirmed because it fits clearly within this court's precedent as a logical extension of what this court has already held about the right to privacy, and the statute at issue here does not pass strict scrutiny.
Counsel, we've held that substantive due process should be used sparingly and have been reluctant to expand the areas that substantive due process goes into. Given that the Fourth Amendment already covers this area, why should we expand this to the substantive due process area?
Your Honor, the Fourth Amendment is not the most apposite part of the Constitution to cover this area. The Fourth Amendment has been used by courts in the context of criminal cases, and those cases implicate very different concerns than non-criminal cases that might be covered by the 14th Amendment. this court most recently has held in Maryland v. King, as previously discussed. But in that case, the statute allowed the use of DNA after there had been arrest for probable cause. That DNA was only used for identification purposes. And in fact, the statute required that if the person arrested went to trial and was acquitted, that DNA must be destroyed. So this court noted that those were very important procedural requirements that met those rights to privacy that even people in the criminal system have under the Fourth Amendment. In that case, there was a non-speculative interest that the state had in the identification, safe custody, and bail assessments that could all be helped by finding the DNA. In this case, those just aren't the interests involved, and any interest the state does have are quite speculative.
Well, the state has a strong interest in preventing the spread of this disease.
We do not dispute the state's compelling interest. We do dispute the tailoring of this statute for meeting that interest. Part of the reason for that is because the statute is much too broad and allows for and the way the city has used this is to do medical testing and spend a lot of time in laboratories and take a lot of people's information, as was admitted in the record, that the city collects DNA under this statute whenever practical. So they have been using this statute to collect DNA and use it, and they assert that their interest is in curing the disease. However, that's not the least restrictive way to combat the disease, because the contact tracing that they have been doing is a way that they can find who has been infected and prevent them from coming in contact with other people.
Did they need to do the cheek swab with DNA testing in order to find out who was positive?
The DNA is not necessary to figure out who is positive for Green Isle. The DNA, especially in this case, the city is interested in it because they believe that Rosemary might have an immunity to Green Isle, and they hope to use her DNA to perform research.
So does the record indicate that the cheek swab was used for determining whether she was positive, but not through DNA sampling, through some other test? What was the purpose of the cheek swab other than to decide whether she was positive? Is there some other way to determine whether she was positive?
Your Honor, the dispute here is not necessarily that the city needed to determine whether she was positive for the disease. The dispute is the city's taking of her DNA in that process and the retention and use of that DNA.
What impact should the fact that your client consented to the swab have on our analysis?
Your Honor, the city itself admitted before the 14th Circuit that Rosemary did not consent to the procedure, and the circumstances indicate anyway that she was under pressure from a city health inspector at her door who was putting pamphlets in her face telling her that they could take her DNA, but the city itself admitted that there was no consent there.
If the city had obtained the DNA by, say, picking up a piece of her hair when the inspector was there rather than doing the cheek swab, would you still be arguing that her rights have been violated?
Yes, Your Honor, because if they had done that and taken her DNA without her consent, that would have violated the right to privacy that we argue she has in keeping her DNA to herself if she wants to.
What if she had left a coffee cup at McDonald's on the table and the city had picked up the coffee cup and done the DNA sequencing from that? Would she have a privacy right violated there?
That would still implicate her right to keep her DNA private.
But she would have abandoned the coffee cup in my hypo.
Yes, that is true, Your Honor, but she did not give up any of her right to keep the most personal information about her body private.
What's your best case that's been decided by a court for that principle in my hypo? Is there a case?
Not that I'm
No
aware
one's
of.
thought of that one.
Yes, Your Honor.
And-
This
and
is
so-
a very new issue.
Sort of following up on that, counsel, you keep harping on your client's right to privacy, but which circuit's approach to medical privacy should we adopt here?
Your Honor,
Which circuit's approach to medical privacy is consistent with your position?
many of the circuits have held that there is a fundamental right in privacy to medical information. But what we would say is that DNA is such a new and special category of medical information that the approaches that the circuits have taken to other types of medical information are not exactly what is needed in this case.
So, for instance, the Third Circuit's approach in Westinghouse, is that the standard we should use?
The Third Circuit's approach would be a better standard. It certainly holds a very high standard for medical records, which is appropriate. DNA, however, is the most personal medical information that we can have because it determines almost everything about our physical bodies, and it can even reveal present and future conditions that we have.
If they had collected the DNA, but done it in such a way that there was no identification back to her, some sort of totally anonymous, de-identified, this is DNA that seems to show its surprising resistance and we need to analyze this, but with no way of connecting it back to her. That is there a privacy problem? Because then it's not her personal information, and it's just this particular gene pattern might have a way of curing this noxious disease. But there'd be no, concern with stigma, discrimination, because it wouldn't be linked to her.
Your Honor, in that case, it still implicates the fact that Ms. Deacon should be allowed to determine what happens to that information about her body.
What if it came from the coffee cup that she'd abandoned?
Again, Your Honor, Ms. Deacon has, and all people have, that right to keep that information private.
Could she have a reasonable expectation in privacy, though, if she abandons her coffee cup and the DNA is on it?
Your Honor, and that's part of the problem, is that our DNA is all over the place, and it would be very easy for people to harvest DNA from places like that and use it without any repercussions. Now, especially this
Does
becomes...
that mean you agree she wouldn't have a reasonable expectation of privacy on the abandoned coffee cup? Are you saying that's true, but we should use a different test? Or are you arguing that she still has a reasonable expectation of privacy?
Your Honor, we would argue that you always have a reasonable expectation of your privacy in your DNA unless you have made some affirmative step to give up that right, like you've consented to some kind of medical testing, you've consented to using your...
Or you left the coffee cup and abandoned it.
I'm sorry, Your Honor?
Or you left the coffee cup and abandoned it. That's an affirmative act.
Yes, Your Honor, but nobody who leaves a coffee cup is expecting that they're giving up their right to have their DNA private. If that were the case, nobody could go anywhere or do anything because their DNA would be on something.
But their fingerprints, you would agree, can be ascertained by the police if they leave their coffee cup abandoned in a McDonald's, right?
Could be, Your Honor, but fingerprints also are less sensitive than DNA and contain less personal information. Part of the concern, especially with people being able to pick up DNA without repercussions, comes in the area of human cloning. Now, it would be a serious violation of a person's right to make decisions about their body if somebody can come along and clone their body. Now, while we don't immediately have the technology to make that work all the time, betting our policy and our constitutional rights on the assumption that technology will not advance there is not the approach that this court has taken or should take in this case.
Let me ask you this, counsel. I'm trying to get to the bottom line here of your position. Is the bottom line of your position that while the city had a compelling interest in certainly responding to this disease and testing your client and others to see if they were positive, once she was not positive, that their compelling interest in that manifests itself in the sequencing of her DNA and the retention of her DNA ended? Is that In other words, once she was not positive that, in your mind, in the state's interest in eradicating this disease as it related to your client.
Yes, Your Honor. The state's interest is not in eradicating the disease through finding a cure. So what the city was doing when it was taking DNA was hoping to use it for medical testing. Now, that is the city's regular policy of taking DNA whenever possible.
But you're distinguishing that interest from the interest in eradicating the spread of the disease.
Yes, Your Honor. So
If we find that there is not a right to privacy and the rational basis test applies, can you win under the rational basis test?
yes, Your Honor, we think so. Because, first of all, the statute allows for the preventing of the spread of diseases. There is no specific statutory language allowing the eradication of diseases. So we think that that's an extra textual use that isn't grounded here in the statute. Furthermore, this statute is overbroad and is used in ways that do not further compelling interest generally, because the city's agent, Tony Love, admitted that they use the procedures more frequently than you'd think, and that the city has used those procedures for particularly bad outbreaks of the flu. Now, that kind of use of the statute shows that they're not even looking at their compelling interests, and that this is just much too broad generally to even be constitutional at all.
So the record shows that they've been doing DNA sequencing on people with testing positive for the flu? Is that right? I'm trying to clarify what the record shows.
That is not specifically stated, but it is certainly the implication from the fact that the record shows that the city takes DNA whenever possible, and that it does use these procedures, has used them for outbreaks of the flu.
Am I correct in understanding the factual record is that one of the reasons the city maintained her DNA sequencing information was for the hope to be able to contribute to an antidote to Green Isle?
Yes, that was their stated reason for sequencing the DNA when they thought that she might have an immunity because she didn't show symptoms.
That seems to be an awfully important public health purpose that the city has.
It is, Your Honor, but there are other ways. First of all, the eradication, again, is not the most closely tailored way of doing that, and if they wanted to use her DNA, hopefully to find a cure, then there were other ways the city could have gone about it. They could have tried to get consent from Rosemary and talk to her about the importance and their hopes for using her DNA, and given her some confidence that they were going to use her DNA appropriately. In this
Why
case,
would that be applicable here, though, given the time sensitivity? People are dying within a 3-week period of showing any signs of this new disease. So to expect the city to have to go out and get consent from everybody who they want to swab and sit down with them and explain all the pros and cons, why is that reasonable here?
because, Your Honor, first of all, it's going to take a long time to even develop some hope of a cure anyway. So
is that in the record?
It is the experience of developing medical cures of all types.
So you are inviting us to speculate.
It's not as much. It is not a
Taking the invitation back.
Sorry.
Thank you,
My
Counsel.
time is up.
Thank you.
Your Honors.
Buttle?
Your Honors, I will spend the remainder of my time addressing the strict scrutiny analysis issue. As my friend on the other side highlighted, the city is utilizing contact testing for this statute. contacts tracing, my apologies. Under that method, we are ensuring that the individuals who come into the impact of this statute are only those who are at risk of either transmitting or have come in contact with this disease. With regards to whether or not the buccal swab was the most necessary choice, the statute has outlined 4 potential tests: a nasal swab, a buccal swab, a blood sample, or a urinary sample. Accordingly, circuit courts have often highlighted that the buccal swab in comparison to a urinary test or to blood tests is least intrusive and one of the most painless of the potential options. That was likely why Mr. Love selected that, because it was the least intrusive option of those 4, which are all common medical practices with regards to tracking the spread of disease.
But we're not talking about how intrusive was it for them to take the sample. The question is the sequencing and retention after a determination that she was in fact not positive. That's something different, isn't it?
With regard, again, Your Honor, with regards to the retention of the information, that was for the purpose of eradicating the disease. And from all the cases that exist with regards to a court's analysis of the spread of the disease, the inevitable conclusion is the best way to prevent the spread of the disease. To develop a cure that can stop it from spreading through and continuing to kill hundreds of our citizens would be the inevitable conclusion of a statute that's designed to prevent
dramatics aside, that still doesn't account for immediacy versus remote. We all continue to hope and cheer for the eradication of cancer and support the research, but that does not speak. That's something different than attacking an immediate outspread of a disease or a virus, which the state and the city have the right to try to eradicate immediately for the protection of the public. These two things seem different to me.
Your Honor, on pages 23 to 24 of the record, where it details the reasons in which the city collects and maintains the DNA information, it highlighted that the reason that they were maintaining some of this information was for addressing the issue in the near future. They were looking to establish enough potential immune individuals that they would be able to
but
utilize.
Here we go again, near future. Near future, I mean, seriously, counsel, is there anywhere in the record where the city has established or there's any evidence that with the collection, retention, sequencing of DNA, that there was a specific plan or protocol that would have allowed them to address or have the possibility of eradicating this disease within a relatively short period of time?
Madam Justice, may I answer?
Answer yes.
Your Honor, there is no particular mention in the record that there was a time frame or a set procedure. With regards to the general time that they had held the information, it was for only 88 days. The average for most statutes across this country with regard to the retention of medical information for the purposes of eradicating diseases is usually at its lowest 3 years, at its highest usually 10, and that this would have fallen well within those boundaries. Thank you for your time.
Ms. Sears?
May it please the court. My name is Haley Sears, and I represent the petitioner of the City of Lockton. This case is about the City of Lockton, a small municipality with limited resources who, despite having a cybersecurity system that is 2 times more secure than the industry standard, suffered from a data breach. It's about the federal courts exercising jurisdiction over cases and controversies as mandated in Article 3, and not over mere speculation of future harm. And lastly, it's about the overriding and time-honored concern this court has had about keeping the judiciary's power within the proper constitutional sphere. We believe we're entitled to have our case reversed and remanded because Ms. Deacon did not suffer an injury in fact, and therefore does not have standing under this court's certainly impending or substantial risk standard in Clapper.
Counsel.
Yes, Your Honor.
Why isn't the Seventh Circuit's standard that's set forth in, I believe it's Remedios, and also followed in the 6th, 9th, and D.C. circuits. In other words, that the increased risk of identity theft is sufficient for Article 3 standing. Why isn't that the proper standard?
Well, I'd first like to distinguish that in those cases, specifically Krautner in the Ninth Circuit and Rimahas in the Seventh Circuit, a named plaintiff in those cases alleged misuse or access of their personal information by the thief. We do not have that in this case. Ms. Deacon is not alleging misuse, but rather the future harm of her injury.
But isn't she, in fact, at risk? We know the information is out there, correct?
Yes, Your Honor.
Once your information is out there and you are exposed as a result of a hacking, assuming that negligence can be established, but aren't you harmed at that point? Do you really have to wait until the hacker steals your money out your bank account?
We believe under the certainly impending and substantial risk standard you showed, Your Honor. In this certain case, Ms. Deacon is relying on a list of contingencies to occur before her information is actually misuse. In Clapper, it specifically said that those an injury which depends on the occurrence of a series of possibilities, none of which is certain to occur, is insufficient. We find no different.
Weren't there, in fact, 5 people whose DNA information was misused in this case?
Yes, Your Honor. There was 5 individuals who had their bank accounts fraudulently opened.
I thought it was 2 individuals with the bank accounts, but there were 5 individuals with their DNA actually misused. Am I misrecalling the record?
I believe it was 5 individuals who had fraudulent bank accounts and 2 individuals with their genetic sequence was sold.
So the fact that there were others of the 300 or so who were affected by the theft, who had the exact problem that Ms. Deacon is worried about, shouldn't that factor into the certainty issue that the Supreme Court talked about in Clapper?
We would argue that it wouldn't. That this court has repeatedly reiterated in cases such as O'Shea, Lyons, and Rizzo that these past wrongs do not in themselves amount to the real and immediate, certainly impending threat, injury necessary to make out a case or controversy. So the existence of a past injury or nor speculation of the possibility of future injury in these cases rises to the case and controversy needed to establish standards. So just because it's happened in the past, Your Honor, doesn't mean it'll happen in the future. We just do not know at this point.
But in this case, isn't it a fact that the grim breacher had actually hacked into other hospitals and medical facilities to steal the same kind of DNA information?
Currently no arrests have been made in this case to certainly establish that it has been the grim breacher. Assuming it was a grim breacher, we would also like to argue that under these cases, while it shows that there was intent to use this information maliciously, as I don't know a lot of hackers that use them for goodwill purposes, but we are making the argument that her information hasn't been misused yet, that out of the 4,638 individuals that had their information copied on page 47 of the record, Ms. Deacon was only one.
Can't we reasonably infer, though, that the hacker took this information in order to misuse it? What other reasonable inference could there be for the hacker taking the information?
Yes, Your Honor, and we're not arguing that there was other reasons for the hacker taking the information.
Okay.
What we are arguing is that shouldn't be enough. Under this Spokio standard, when it has to be concrete and particularized, actual and imminent, we're arguing that it doesn't meet those standards, that it isn't concrete and particularized, and it isn't actual and imminent, as her information hasn't been misused yet, Your Honor.
So at this point, I recognize that it's only been a few instances of misuse. If it got to a point where half of the accounts had been, half of the people whose data had been taken were used to open fraudulent accounts, at that point, would you agree that, of course, it's an imminent and particularized risk?
Your Honor, I wouldn't want to put a number on it because this varies in various situations. But I would want to once again point back to this court's decision in Lyons, in which the only way in Lyons that decided that a past wrong could meet the real and immediate, certainly impending standard was if the defendant could show, or the plaintiff could show, that it always happened, or that there was a mandate that regulate it to occur.
But isn't this case different from Lyons in that it's an ongoing event, in that, according to the record on page 25, 5 people's genetic sequences have been sold or offered for sale online, suggesting that the Grim Reaper is just beginning an ongoing process of offering all of the people affected, including Ms. Deacon's situation, to have their genetic sequencing disclosed.
Yes, Your Honor, and we would once again point back to the contingencies that have to occur. Ms. Deacon relies on the likelihood that the thief will locate her file in the 4,638 files, read the notes therein, understand the abbreviations, understand the potential economic value, and then misapproach her genome to malicious ends. It's not certain that any of these events will occur, let alone the probability of all 5 is even less.
Isn't Deacon the only one, though, that has the medical notation in her medical records that she's a possible source for immunity to this disease? Isn't
Yes,
she
Your
the
Honor.
only one? And so anyone filtering for that?
Right, and does that not
target
make,
her.
I'm sorry, I'm sorry,
Go
Dan.
ahead, go ahead.
Does that fact not make her potential immunity, make it more likely that in fact her genome will be misappropriated and sold to medical researchers or the pharmaceutical industry?
In both of your honors, I would definitely agree with you if we had information that her file had even been accessed or opened or looked at, but we don't have any of that information. We don't know that even he has seen the possible abbreviation in there, nor understood it, nor even opened up her file.
Yet. But they have, I mean, it's not, it would be, I get your argument, and I think it would be a little different if we had no information, or if we had no information that that any of the hacked information had been used or viewed. But we do know that has been accessed, it has been utilized, and with these other factors, it just seems to me that it makes it more likely, in fact, that particularly the market for medical research, that it will be.
So I'd like to distinguish Ms. Deacon's case from other decisions in this court, specifically Monsanto and in Scrap, in which the alleged future harm met the certainly impending and substantial risk standard that I'm arguing for. In these cases, these harms were readily attributable to the government action, and this is key here. They were not waiting on an independent actor to intervene. In these cases, it was just the first domino in a row was hit, and we were just waiting for the rest to fall down. But in both Clapper and Lujan's, when referring to future harm, this court stated that plaintiffs cannot rely on the unfettered choices made by independent actors not before the courts.
Counsel, let me ask you this, though, as it relates to Clapper.
Yes,
Clapper did not abrogate the substantial likelihood standard and Krotner's credible threat standard. That was not abrogated by Clapper, was it?
Would you mind rephrasing the question, Your Honor?
Sure.
Thank you.
You mentioned, or you referred to this court's decision in Clapper. Would you agree that Clapper, however, did not abrogate or do away with the substantial likelihood standard that's set forth in previous case law, or the credible threat standard of Krotner? In other words, that those standards are not inconsistent with Clapper, are they?
I would argue that they are, that the reason that Clapper put forth the substantial and risk and certainly impending scenario was to try to put forth a uniform way of settling these cases.
But why wouldn't the court have specifically abrogated its prior standards if it was creating a new one?
That, Your Honor, I just don't know. I can't speculate why the court did that, but I would adhere to this certainly impending and substantial risk standard of this court, since it is the highest court in our country, Your Honor.
If I could draw your attention to the state construction of what the state law provides, and we're talking about this in terms of a negligence claim, right? So why shouldn't we, under the Erie Doctrine, apply the full negligence law of the state, which does define this as a valid claim, and therefore there should be standing, even though we apply federal Article 3 principles.
Yes, Your Honor. In Hollingsworth v. Perry, this court analyzed a similar issue, dealing with whether they should apply a California law as it was interpreted by the California Supreme Court. In this certain instance, we're dealing with the same type of issue in which...
Was Hollingsworth a diversity case? It couldn't be because it was the state of California versus a person in California.
Your Honor, I'm not quite for sure how they were getting into federal court, but the Supreme Court here found that they didn't meet the particularization. And I don't want to focus on the particularization requirement, but I do want to look behind and what Hollingsworth v. Perry, the justices, were really discussing. Here they were balancing the difference between the federal interest and the state interest.
But shouldn't it make a difference if it is a diversity case that under Erie, we apply state law?
Under Hannah v. Plumer, yes, Your Honor. But when the U.S. Constitution does not control and Congress hasn't legislated, then the states, laws of the states necessarily govern. But here the U.S. Constitution does control, and therefore this court is bound to apply Article 3 standing. In Summers, this court specifically said that Article 3 standing is the floor to get into federal courts.
Could this claim be brought in state court, the negligence claim?
Yes, Your Honor. Ms. Deacon could bring this action in Arcadia courts.
So any disposition that we make in this particular case would not preclude under res judicata principles a subsequent action in state court?
I do not believe so, Your Honor.
And doesn't it matter? You're asking us to apply Hollingsworth, but that did involve particularization, not the concreteness. Doesn't that matter here?
Your Honor, I'm about to run out of time. May I answer your question?
Definitely.
Thank you. We believe that because in Spokio you need it to be particularized and concrete. I mean, it's like peanut butter and jelly. You can't have one without the other. And so we would put forward.
I might disagree with that.
Okay, that's for another day. For me personally, you can't have one without the other. And so under Spokio, it needs to be particularized and concrete, Your Honor. Thank you.
Thank you. Ms. Meredith?
Madam Chief Justice, and may it please the Court. My name is Celia Meredith, and I represent the respondent, Rosemary Deacon. We are here for a harm that deserves redress. In June of this year, the grim breacher hacked into a third server in Arcadia, putting the sensitive information of thousands of Arcadians, including Rosemary Deacon, at risk, threatening their livelihoods, their safety, and their peace of mind. We ask this court affirm the circuit court decision and find that this hack has caused Ms. Deacon an injury in fact sufficient to establish standing and maintain a negligence claim for two reasons. First, an increased risk of identity theft after a data breach is sufficient to establish standing under Article 3. And second, because state-recognized harms may appropriately inform standing analysis for federal courts sitting in diversity.
You are, it sounds like, advocating for the standard that the Sixth and Seventh Circuits have adopted. If we apply the standard that the First, Second, Third, and a couple of other circuits have adopted, can you meet that burden?
Yes, Your Honor, although we do argue that the Third and Fourth Circuits, for example, in Beck and Riley, have more closely followed the certainly impending standard that was articulated in Clapper, which we believe to be incorrect in the context of data breaches. The substantial risk of harm was also articulated in Clapper, where this court acknowledged that there are different kinds of harms may require different kinds of tests.
Why is Clapper inapplicable to the data breach area? What have we said anything that leads you to conclude that?
So in the certainly impending standard, first Clapper did articulate both of those, but the certainly impending standard was used in Clapper because Clapper specifically dealt with a threat not only to national security, but also questions of proper separations of power. This court acknowledged that that would thus require a higher standard to ensure that the constitutional needs were being met. A substantial risk of harm, on the other hand, appropriately balances the prudential concerns of Article 3 standing while embracing a more modern conception of increased harm that comes as data breaches become more common and more personal information is put at risk.
So what's the line that you would ask us to draw as to when each of these standards applies? Is it just in national security threat cases that the higher standard applies?
There may be other instances in which the higher standard applies, but for data breaches specifically, the substantial risk of harm is more appropriate. And when looking at substantial risk of harm, there are three things that lower courts have looked to that are appropriate to examine further in data breaches.
Well, I want to go back a little bit because I'm still a little uncomfortable on the standing issue as it affects our jurisdiction. Mm-hmm. And I guess the question is, why should a state court be allowed to define the elements of our federal jurisdiction?
In this instance, the state law would not be defining standing overall. We agree that Article 3 standing applies, but that within Article 3 standing, the injury in fact prong incorporates substantive legal aspects in examining what sort of harm deserves redress. Now, in Spokeo, this court said that an injury in fact must be an invasion of a legally protected interest. Because this is a negligence cause of action and the state has defined a harm that deserves redress, that harm can be incorporated into the injury in fact standing. So this court would rather be referencing the Arcadia Supreme Court, which is better situated to define harm under Arcadia state law, to be included in Article 3 standing, rather than saying that Article 3 standing does not apply, which is not correct. This case was brought in federal court, and we need to meet that Article 3 minimum standing. To continue speaking about, because first there are multiple injuries here. The question of state harm looks to the harms set forth by Arcadia, so anxiety and a breach of trust, which was acknowledged in Witt versus Jean Genie. But Ms. Deacon also, as my friend on the other side has mentioned, is suffering from an increased risk of identity theft. Now, an increased risk of identity theft can be a future harm sufficient to establish an injury in fact under Article 3 standing when we examine three elements of the data breach. First, the information that was at risk. Second, the intent of the hacker. And third, the actual access to and misuse of that information.
What's the authority for that proposition?
So it's examining a number of cases for the kinds of information. We can look at, for example, Krotner and Ramijas, in which case in Krotner, where names, addresses, and social security numbers were accessed on an unsecured laptop, the court found that that information was sensitive enough such that an increased risk of identity theft was an injury in fact. Similarly,
that's a lower court. That's not us talking, right?
Correct. This court has not yet had a case of identity theft attendant to a data breach. And so by looking at the lower courts, we can examine how individuals can show a substantial risk of harm, which is meeting a test that this court has set out. So adding more details to the test that this court has articulated by looking at the lower courts. So in this case, it was not only Ms. Deacon's name and social security number that were breached, but also her date of birth and her genetic information. All of this information is incredibly difficult, if not impossible to change, and can be used for a long time, which places Ms. Deacon at a substantial risk of identity theft, particularly when we consider the intent of the hacker. As we have already mentioned this evening, the Grim Breacher, this is the third hack of the Grim Breacher. The first was of...
Hold on for a minute, counsel. We don't know who the hacker is, right? How do we know what the hacker's intent is?
Examining the police reports in the record, so on page 47, the police have stated that they believe that this breach was perpetuated by the grim breacher by examining the evidence, the style, and the information taken.
Did a lower court make that factual finding? Did the trial court determine that?
The trial court determined that, and the 14th Circuit also agreed with that finding. So the grim breacher has not only hacked 2 other locations, but has then misused that information. Over 4,000 individuals' information was accessed in the Department of Health breach. Over about 300 of those individuals' information was placed for sale online. 5 of those individuals specifically had their genetic information put online, and 2 individuals have already had bank accounts fraudulently opened in their name.
But your opponent argues that Ms. Deacon should have to wait until her information is actually misused in order for this to be available for standing purposes. How do you respond to that?
Respectfully to my friend on the other side, we believe that that is under an incorrect usage of the standard. Using the certainly impending standard is exactly inappropriate in data breach cases for this very reason. To leave people until their information has already been misused leaves them with very little redress, and also means that if years down the line, if that's how long it takes, the grim breacher finally sells Ms. Deacon's information and the statute of limitations has run, the city could very easily say, well, we're very sorry for your loss, Ms. Deacon, but there's nothing we can do about it.
So wouldn't this, sorry,
Go ahead. No,
wouldn't this apply then to all of these credit card information thefts? That even if the hacker hasn't used the information yet, down the line, the hacker could use the information, and therefore people who are, have a credit card with the XYZ company where it was stolen can bring suit now. Isn't that a problem?
So there are instances, particularly looking at the Third and Fourth Circuit, where plaintiffs who did not necessarily have, or my apologies, in the Seventh Circuit for credit card information, there were plaintiffs party to that suit that had not had their credit card information misused yet, and were still able to have an injury in fact because of the likelihood that their information would be misused. And there is a distinguishing factor in this instance where it's not just credit card information that is at risk, but social security number, date of birth, and genetic information. So this is information that is even more sensitive. And looking to cases from the Third and Fourth Circuit, such as Beck and O'Reilly, which did not find an injury in fact because there was no, quote, change in the status quo, again, leaves plaintiffs with little redress and focuses too much on the economic factors at hand.
So would you contend that the data breach itself was sufficient to give her an injury? In fact, that is, if there weren't yet evidence of any misuse, would you still be arguing that there is this risk of future harm?
No, Your Honor, because again, it's not just about the hack. It is about, again, the information. Yes, the information that was involved.
Same information taken,
yes,
but it has not yet been misused by the hacker.
It depends on the intent of the hacker. If there is evidence that the hacker has a very strong likelihood of criminal misuse, as both the Seventh and Sixth Circuits have mentioned, presumably the purpose of a hack is to fraudulently misuse information or to assume an individual's identity.
Well, then that is suggesting that basically any breach of cybersecurity could give rise to countless lawsuits by people whose information would never be used.
And that is why the third prong of that test, the actual access or misuse of information, is incredibly important. We know for a matter of fact that the grim breacher has accessed over 4,000 files. About 300 of those have already been put online. So not only do we have evidence of actual access, but there's also misuse from other individuals that show that the risk to Ms. Deacon is not speculative. She is in a substantial risk of harm.
Well, suppose it had been misused only in 2 instances out of the 4,900 files taken. Would that be enough?
It would likely not, Your Honor. That's a very
So where do you draw the line?
I wouldn't know where to draw the line because it also depends still on the information at risk and the intent. Even if this court, though, does not find that an increased risk of identity theft is sufficient for an injury in fact, Ms. Deacon still has suffered a legally cognizable harm under Arcadia state law. As I mentioned,
Before you go there, you said you don't know where to draw the line, but we need to draw the line for future litigants so that they know when they're standing and when there isn't. What test would you tell us to adapt? If there's no evidence of any other, or the hacker's intent, or if there's very little evidence of the hacker's intent, where do we draw the line?
it's a balance. It would be a balancing test still, Your Honor, examining in relation to one another the information at risk, the intent, and the actual misuse or, my apologies, the evidence of access or misuse. These things must be balanced together.
There has to be some evidence of misuse. How much evidence of misuse?
Evidence of access would also be sufficient by looking at the courts that have already decided on this. They balance both access and misuse. Oftentimes it seems to depend on how much information was breached. There were thousands of individuals' information that was breached here, which suggests that there's a greater likelihood of individuals being harmed.
To what impact, if at all, does Ms. Deacon's potential immunity to the Green Owl affect the standing analysis? In other words, the likelihood, or does it at all? Does that factor into the balancing test?
Yes, Your Honor. It would go into the kind of information. So, as we mentioned, her genetic information is at risk. The fact that there's evidence that she has a very rare immunity to a noxious disease means that that information is that much more sensitive, and that the kind of information is overall more sensitive, lending more weight to there being a substantial risk of harm. Now, as I mentioned earlier, examining state-recognized harms does not say that Arcadia standing law supersedes Article 3 standing law. That's not how federal courts work, and that's not what we're arguing for. We're simply arguing that for a federal court sitting in diversity, the court will look to federal procedural law and state substantive law. As I mentioned, injury in fact incorporates at least some substantive aspects when examining the kind of harm that deserves redress.
Have we ever allowed state law to define standing in federal court?
To define standing?
Right.
No. To support standing, yes. For example, in Kentrell v. City of Long Beach and in Spokane, the court also acknowledged that injury in fact must be a legally protected interest, which may be supplied by state law. For the foregoing reasons, we ask that this court affirm the 14th Circuit. Thank you for your time.
Thank you.
I'd like to first address Justice Moore and Justice Wyeth's concerns about the larger credit card companies in which these have been hacked.
Counsel, I would actually appreciate it and ask, because I'm still hung up on this whole issue of standing based on state law.
Yes, Your Honor.
Your opposing counsel just indicated that there is a distinction between state law defining federal jurisdiction and federal jurisdiction being supported by state law. How do you respond to that?
I would respond by having the court look to in town of Verona, in Trebur, in Makarova. There's a Second Circuit, a Northern District of New York, which was affirmed by the appellate court, and then another Northern District of New York. The plaintiffs here asserted that they had standing under a New York law, and that because they have a clear cause of action under state law, standing cannot be eliminated by removal to federal court. The court held that plaintiffs are incorrect. Although states are free to grant private rights to bring generalized grievances in states' courts, state law cannot overturn Article 3 limits on federal court standing. We would argue that the injury, in fact, is an irreducible minimum of Article 3 standing. Allowing this would disrupt the concerns that Hollingsworth had for ensuring that limitations on standing are founded in concern about the proper and properly limited role of the courts in a democratic society. So just because...
Can state law ever help define harm for the injury in fact analysis?
Yes, Your Honor, if it meets Article 3 standing. We don't argue that states can't create their own laws, that they can't, but there's a reason why sorry, may I finish my question? There's a reason why state laws and the state Supreme Courts do not have to apply Article 3 standing. Both of the courts are created separately for a reason, and because Article 3 standing isn't mandated in the state courts, the federal courts are bound to casing controversies in Article 3. Thank you, Your Honors.
Thank you. Thank you all for your thoughtful arguments. The court will adjourn and deliberate on this case, and we will be back shortly.
All rise. Please remain standing.
Thank you, everybody, for sticking around for the arguments. Let's give a round of applause for our competitors, please. If you were a competitor in this year's competition, you're probably going to want to stick around. We have a special treat for you. We have a video commemorating the Moot Court problem this year. So trust me, you won't want to miss it. Everybody else, you can feel free to either stick around for the video or there's hors d'oeuvres out in the hallway. And please don't go too far because our judges will hopefully have the results soon. Thank you.
An officer took a DNA sample. It was a simple swab of her cheek, which Rosemary did not consent to. What the police found out was that they were right. Rosemary did, in fact, have green isle virus. What nobody expected, though, was that Rosemary remained in good health. Apparently, she was immune from the virus, the only recorded instance of immunity thus far. Afterwards, a legal battle began, in which Rosemary sought to protect her DNA as her property, while the authorities argued they were entitled to use her DNA for the greater good. Making things more complicated is that a hacker, nicknamed the Grim Reacher, stole data from the authorities and sold it on the black market. Now, we take a closer look and hear from the people involved in this case. We should note that our normal investigative journalist, Samuel Chan, has fallen ill from the virus himself. Instead, we have Robert the Bruce, whose only qualification is that he happens to be the son of the owner of this TV station.
Thanks, Mom, and welcome to my brand new show, Between Two Arcadian Birds. You know Dasher and Dancer, Donner and Blitzen. But my next guest is perhaps the sickest, most contagious reindeer of them all. His name is Rangifer Pterodontis Dentis Tarantula. Please welcome Rangifer Tarandus.
Thanks for having me. Really happy to be here.
Great, you're welcome for being here. Now, I thought Rangifer was a girl's name.
That's more of a modern thing. Back where I came from 50,000 years ago, so it was usually a boy's
mistake. So, Ms. Rainford, I have to say, for an extremely sick and contagious 50,000-year-old reindeer carcass, it would actually look pretty good.
Thanks, I really appreciate it. Just trying to take care of myself, make sure I'm eating well, all that good stuff.
What's your secret?
Well, like I said, diet is super important. Moss, various lichens go along.
Gotta love lichens.
Yeah, they call it paleo diet nowadays, but it's more current back 50,000 years ago.
Speaking of self-care, why did you want a murderous rampage? Is it because the other reindeer used to lavish you with fun things?
No, actually, I was extremely popular in high school. On the lacrosse team, jazz bands. I had a bunch of friends. Jimbo, Maxie, Lars. No, that's good buddy Lars, good friend of mine. The high school was great.
Did you know Santa?
It's actually a common misconception. Santa is not real.
Neither are talking reindeer.
Touche.
So, what's next for you? You have another city in mind?
I'm thinking about going to Tampa. It's pretty nice this time of year. Want to keep this whole self-care, relaxation R&R ball rolling. So thinking.
Hey, I will warn them. Well, thanks for stopping by, and good luck with your disease.
Thank you. Appreciate it.
Later. All right, and we're back on to Arcadian Ferns. Our next guest is Rosemary Deacon, the plaintiff. Welcome.
Thank you for having me.
You're welcome. So, two first names. Your parents must have been pretty rich still before that.
And how much did your parents pay to have the be your real name?
I'm from Ohio. They met at the Ohio State University. Obviously. So, anyways, what's all this fuss about? Someone took your saliva and now you're all mad?
It's not about my saliva, it's about my privacy. And the privacy of more than 300 million Americans. This is a serious issue. I appreciate it if you would treat it as such.
Obviously, it's so important. I took one of those ancestry tests one time, and it said that I am 50% Greek god.
Well, I actually had a DNA test, and it turns out I'm 100% that person who's immune to Green Isle virus.
I'm sure it come back and said 50% boring.
What's that?
Sorry, just before we continue the interview, you've got a little booger coming out of your nose there, just for the camera.
I'm so sorry.
It's really distracting, honestly.
Oh, I'm so sorry.
I've got a track.
Oh, thank you so much. I really appreciate it.
So important to make sure that we have everything exactly right. Obviously, just go ahead and collect that. Okay, continuing on now. So you've got this immunity, and just curious why you're not willing to share the potential benefits of this. They've been telling me that this could lead to a breakthrough, a potential cure. Do you not care if your fellow Lockton citizens are cured?
I don't have my attorney present. I can't really comment on any of the legal issues in this case.
Of course, hide behind the law. Typical. Anyways, I've had athlete's foot for 3 years. It's rough. I would like to think that if one of my fellow Wattonian citizens had a potential cure in their mouth, they'd let me swab it.
That sounds like a you problem. You can go to CVS and get some Gold Bond. That's something that you can live with.
I've tried, and I'm pretty sure my point's still valid.
Not really. Come up with your foot. I need to go.
Feet. Both feet. But thanks. You're all right, bro? Yeah. All right. And welcome back to My next guest is Italian that also has the green eye virus. You might know him from the college bars around town where he looks older than everyone else. He looks familiar, but you don't know why. Please welcome Mike.
Good to see you again.
Wait, do you know me?
Yeah, of course. You're that guy.
I think
You're the guy.
Oh. Cool. Alright, so I understand you have the green eye virus.
I do?
Yeah. You tested positive. And you look terrible.
I guess I've been feeling kind of funny recently.
Are you worried?
About what?
The virus.
No, my mom, she always used to tell me, she had this saying, and it goes, tell me something, boy. Aren't you tired trying to fill that void? Or do you need more? Ain't it hard trying to keep it so hardcore?
Yeah. So is your mother Lady Gaga? Mike?
And that's all we have for tonight. Good night.
seated.
All right. Okay, this works. Yes. Okay. Well, thank you all again. I know everyone has thanked you for coming, but again, thank you so much for coming, listening to our fabulous finalists, and giving them your full attention. Before we introduce you to our esteemed panel of judges, I wanted to do just a quick thank you to Professor Inga Vandercruz for all of her hard work and dedication recruiting and contacting and getting everything to these judges. So if we could give her a round of applause, that'd be great. So tonight, for the United States Supreme Court, we have the Honorable Karen Nelson Moore. Judge Moore sits on the United States Court of Appeals for the Sixth Circuit. We have the Honorable Amy St. Eve from the United States Court of Appeals for the Seventh Circuit. We have the Honorable Teresa L. Springman from the U.S. District Court for the Northern District of Indiana. We have the Honorable Stacey M. Yandel for the U.S. District Court for the Southern District of Illinois. And we have Dean Deborah Whitus, who is the Associate Dean for Research and Faculty Affairs and a Professor of Law here at Indiana University Maurer School of Law. So if we could give them a round of applause, that'd be great.
We wanted to give our general comments first and to say our congratulations to all four of you. You each did an excellent job. We were impressed with your poise and your ability to answer questions that we threw out at you. And we were trying to be like the U.S. Supreme Court, where the justices even interrupt each other and don't let counsel answer a question before the next question comes, which puts you all in a difficult position in that regard. But we thought that you each answered questions very well and were not flustered by our sometimes opaque and difficult questions. And other times we throw softballs just to see whether you can catch them. One general comment that I'll make, and then we're going to go down the row of comments from each of us before announcing the two winners, is I think one thing to try to do is to come up with some kind of conclusion at the end of your timing. Now, we made it hard for you because we were asking questions till the very end, but when your orange light goes on, you know you've got just a few minutes left. Trying to think of a way to make a persuasive argument, tying it all together, is a good thing to do. But you were all very polite to us and asked for permission to answer when the red light went on, and that's always a good thing. And of course, we always give you permission to answer our questions. It's the question of whether we give you time for your own intent. So we certainly, I think in some of the rebuttals, we were taking charge of the time as opposed to letting you use it. But I thought it was excellent, and you each have a great opportunity as advocates in your future. So congratulations to all of you.
I would just say, I was totally impressed by all of your command of the information, the issues, the facts, and just you knew your material. And I think that what you demonstrated was something that I always emphasized with my law clerks and that I did with the associates in my office when I was in practice. It's not enough to know the what. If you know the why of the what, you can always modify, because then you're applying the analysis, and all of you all did a good job with that. You demonstrated that you didn't just understand the law, but you understood the why of the law, so that when we threw you a hard ball, you were able to pivot, and I thought that was excellent.
I agree. You were each excellent. You should be proud. We are certainly proud of you, and you should be proud of yourselves. I was really impressed with how you were able to really answer and address our questions, not just be stuck to some script that you wanted to stick with, but you listened to our questions, which is the first thing you have to do, and you answered the questions. And even when we were firing a couple of questions at you at the same time, you were able to come back and address each of the questions. I also want to commend the rebuttals, because you did exactly what you're supposed to on a rebuttal. You didn't come up and try to re-argue everything. You addressed what seemed to be the key points during the main argument. So great job. Each one of you did an excellent job.
I want to compliment you on your command of the record. You knew the facts, the underlying facts with regard to the scenario, and you were also able to pinpoint into the record specific pages to tell the court where we could go to find the information that we were inquiring under. You all kept good eye contact, whether it was to the speakers, one of the judges, or just as you were presenting your argument, to look across the entire panel and to keep it interesting and to keep us focused on you and what you were saying. I thought that was well done by each of you. I think you were very polite when you, if there was an issue with regard to the timing of the question or the presentation of a question from one of the judges. I think you used polite language like, if I could ask you, instead of saying, I just don't understand what you just asked me, instead you said, could you please, would you mind rephrasing that for me? And that was very apt, that was very appropriate. You all kept your cool throughout the presentation, very mature. Nobody stumbled on that. I have to be a little bit of a meanie, and just two things that I want to mention to help you with your presentations going into the future. Watch your use of hands. I'm like one of the worst offenders in the world. Mm-hmm. And so I'm very self-conscious of it, but make sure that when you are using your hands in public speaking to not get nervous in doing them, because pretty soon they can become a distraction, and to make it a point to only use them to emphasize a particular point. So being a bad offender, I'm just passing on my recommendation to you to avoid that so you don't get called out on it. Something else that we all tend to do, and that is use certain phrases as we're talking and to put in certain stopgap phrases. So just be careful of that too. Think out your responses before you start talking. That's very effective too when you're doing public speaking, is rather than jump into the discussion and answer right away, take a moment, pause. That has a dramatic effect and also catches the attention of the listeners to wait to articulate what you're going to state instead of rushing into it and again falling into using those type of filler words or languages. So, well done.
And I would just echo everything that has been said before and also add that almost entirely you kept a good pace. And as someone who, when I am nervous, tends to speak too quickly, I was very impressed by your ability to rein that in, because I know that nerves run high at something like this, and to have enough control over your argument that when there was a pause, you knew where you wanted to get back to, and then you were polite if we redirected you somewhere else, but you sort of had in your head, you could tell the map of the points that you wanted to make sure to reach, and you did a good job of being able to go back to them when you had an opportunity. So well done. And I will just add that as someone who was filling in for a judge, I myself was nervous about being on a panel with judges, which just reminded me about how scary it is to be in your position. And so really phenomenal job across the board.
So we congratulate everyone. We understand that our role is to pick the top two advocates tonight. And so we, being obedient civil servants, we did that, but it was a tough choice, and I think everyone deserves congratulations. But we picked the top two as Ms. Meredith and Mr. Coates, and we congratulate the two of you for reaching the absolute pinnacle, and congratulate the other two of you for a job very well done.